8:41. I'm going to call this meeting to order. Commissioner Weston, will you so desperately needed prayer, please?
Let us pray. Heavenly Father, in our hearts we plan our course, but we pray that you establish our steps. I pray that we seek you for advice. Let us not make decisions based upon what we know, but let us act based upon your wisdom. Please guide us, Lord. We place this meeting in your hands. We place our hearts and our minds in your hands so that you may direct us. In Christ's name we pray. Amen.
Amen. All right. Thank you, Callier Butler, for showing up today. And I think we got a quorum, so if y'all can stand by, we'll try to fill your time constraints. Roll call, Tamla.
Good morning. Thank you for being here, Chairman Rick Figueroa,
Here.
Vice Chairman Tom Butler,
Here.
I see you, thank you. Dr. Ray Callis,
Here.
thank you. Dr. Gary Weston,
Here.
thank you. Commissioner Helen Callier,
Here.
thank you. Commissioner Nora Castaneda. You do have a quorum, sir.
Mr. Chairman,
Good, thank you, Tamla. Yes, sir.
I make a motion to accept Commissioner Castaneda's excused absence.
Motion. All in favor, say aye.
Aye.
All right. You opposed? Thank you, Commissioner Carey. Now, Commissioner Butler, I know you don't feel well. Thank you for staying there. I know Commissioner Callier, sounds like you're in a vehicle, so we're gonna try to get through as much as possible. Just quick reminder, make sure your cameras are turned on the entire time. Mute your microphone when you're not speaking. Please raise your hand if you'd like to be recognized to speak, and say your name so that we can get it off the records. So I appreciate that. We're gonna move around a little bit on our agenda. I'm gonna need a commission action item, if you don't mind, for electronic signatures.
I make a motion to authorize Commissioner electronic signatures to be used on orders and decisions for this meeting.
Second.
All right, all in favor, say aye.
Aye.
Opposed? All right, motion carries. Thank you, Commissioner. We're gonna go to audit. We're gonna look at the audits. Mr. Graves.
Good morning. Thank you for having us. I bring to you all the reports for the internal audit function for the fiscal year 2021. Quick overview of those reports that we went over in detail with the audit committee yesterday. The one internal audit that we performed this year was the internal audit over contract administration. That report received a satisfactory rating, which is the second highest rating that we give. There were two findings, both moderately risk ranked, regarding having a complete contract listing that includes MOUs and interagency contracts, as well as performing some monitoring of the certified contract manager certification training for the individuals in the agency that have that certification. The remaining part of our audit plan included follow-ups for all the internal audits that have been that have remaining open findings. The first one over revenue, there were 4 findings that we followed up on. 2 were remediated and 2 partially remediated. Those 2 partially remediated, one has procedures in place, just needs some more time to be able to be in place before we can evaluate the effectiveness of the remediation. And the other one just needed to have a little bit more in-depth review of some fees. The next audit over licensing, we followed up on 3 internal audit findings. All 3 are closed. 2 were fully remediated and 1 was closed by management. The internal audit over enforcement, there was 1 finding that was open, and that finding remains partially remediated. Remains partially remediated due to the fact that it had to deal with some inspections, and due to COVID, the inspectors were not out and performing inspections for part of the year. And then the last one, internal audit over prior year open findings. So these were any open findings that that were open when we became the internal auditor. Of those 2, 1 was closed by management, the other is partially remediated. That one is in the area of the tow trucks moving BSF. Again, due to inspections and the inability to be on site and perform some inspections. That is the one that remains partially remediated. Also in our plan this year was the annual internal audit report, and that internal audit report is prescribed by the SAO. It's a requirement. It has some specified areas. The big part of that report that is not standard and that was chosen by, well, not chosen, but is recommended from me to you as the commission is the internal audit plan for fiscal year 2022. And so in that audit plan, we have all the follow-ups from the open findings and the one audit over fleet management. And we refreshed the risk assessment this year, and fleet management was identified to be an emerging risk as the agency has brought on new areas and new functions and brought in fleets, and now has a budget allocation for additional fleet. As an emerging risk, we thought it was a very relevant and timely. I went over that with management, they agreed. And so that is what we're recommending to be on the 2022 audit plan for next fiscal year. So with that, I'll open for any questions over any of the reports or the annual report in the audit plan. Proposed audit plan.
There's item G. This is the 2021 audit plan. We're still, item H will go next, but any questions on item G? Dr. Callis, do you have any comments on this?
Yeah, but I was going to wait until you ask if there are any questions for fiscal year 2022. Then I was going to put a motion in for in-block voting, sir.
Okay, if there's no questions for G, is there a motion?
I make a motion that we approve the fiscal year 2021 annual internal audit report.
Second.
All right, all in favor, say aye.
Aye.
Opposed? All right, motion carries. Tamla, can you do me a favor? There's a tab over Dr. Callis. I can't see him. I don't know if we can remove that or not, or have Mike look on this big screen in here. Yeah, he's never looked so good though, but I'm not gonna lie, but I just need to make sure he sees his face. So if we could remove that, that'd be great. All right, Mr. Graves, item H, the 2021 plan, 2022 plan, please.
Yes, the 2022 plan does include the fleet management audit and then all the follow-ups for any open findings, as well as an annual internal audit report as required by the SAO and the Texas Internal Audit. So that is the proposed plan for fiscal 2022.
Any comments, Dr. Callis, or anybody?
Yeah, my comment is I make a motion to approve the fiscal year 2022 internal audit plan, and also thank Mr. Graves for a phenomenal job auditing.
Second.
All right, made a motion, second. Any other discussion? All right, all those in favor say aye.
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 Opposed? All right. Motion carries. Mr. Graves, thank you. Thank you and your coworkers for what you did. Appreciate that. Especially highlighting that fleet management. That's going to be something we're going to keep an eye on. Rose, where what things change, the dynamics of our state does. We'll take care of keeping an eye on it. Thank you, sir.
Mr. Chairman, if I could say something real quick, Brian Francis. I want to commend our staff, Tony Couillon, Brad Bowman, for their efforts. They lead our audit review. And so Tony, y'all did a great job. Brad, thank you all so much. Dan, thank you and your team. Appreciate you.
Thank you very much.
Thank you, Mr.
Thank you for
Francis.
having
I'll
us.
second it.
Thank you, guys. All right, minutes. Y'all had a chance to look at the minutes.
Make a motion to
Any
approve.
comments? Sir?
I was making a motion to approve them, sir.
Okay,
Second. Commissioner Cowger, second. Yep.
thank you. All in favor, say aye.
Aye.
Motion carries. It's been approved. Now, Commissioners, I appreciate your efforts being here, so we're gonna jump around and we're gonna go up to motions for rehearing because we have somebody on the line. We're gonna try to take care of that first. So we're gonna jump to item Q. If that's not correct, Mr. Bowman, am I accurate on that?
Yes, sir.
Okay, item Q, and we're gonna go to 1, and that's the Miranda Bloom. And Tama, do we have Mr. Jennings? Where are you at?
Chairman,
Oh, there you go. Well, you moved on me. You're
we're
over
just
there.
shifting around, yes, sir.
Man, do not mess with me today, Mr. Jennings. Not a good day to mess with you. All right, Mr. Jennings is Tamala is the representative counsel for Ms. Bloom online.
Yes, sir. We're moving her into the meeting just now.
Okay, so let me read this to you real quick. Is it Ms. Bloom and it's just her, or is there somebody else?
I believe her attorney is supposed to be on the line, but I'm not.
She doesn't seem to have shown up just yet.
Okay, hang on, Ms. Bloom, okay.
right,
I'm gonna read these instructions to you if you don't mind, okay?
Okay.
Just pay attention and put yourself on mute if you don't mind too, please.
Yes, sir.
It says, thank you so much. So if anyone has indicated they keyed here today for a motion for a hearing, staff has provided them with information on how to connect with this meeting.
Mr. Chairman,
Yes,
Mr. Chairman, I'm sorry to interrupt. This is Brad Bowman, General Counsel. We may want to wait until Ms. Bloom's attorney shows up before.
okay, Ms. Bloom, unmute yourself for a second. We're gonna, your attorney's scheduled to be here, correct?
Yes.
Okay. Just because it's that kind of crazy of a day, I'm gonna stand by with you. Do
Okay.
me a favor, make sure Tamala knows when your attorney, or Tamala let us know when your attorney comes online, and we'll wait back, we'll come back to it. So
Okay.
we're gonna jump to number 2, since we're in the motions for rehearing. I'm still gonna read the instructions, so we can get into this item, and then we'll just get your counsel in there, okay, Ms. Bloom?
All right. Thank you very much.
You bet. Okay, here we go. We good with that, Ms. Bowman? Mr. Bowman?
Yes, thank you.
Okay. All right, waiting for the next grenade to go off, that's all.
I've got one, Chairman. Doug Jennings, Assistant General Counsel. Just wanted to remind you that item number 2 on the motions for rehearing, that motion for rehearing has been withdrawn by Respondents' Counsel.
So do we even need to hear it? Okay, well, yeah, I knew it was just a matter of time, somebody pulled the pin. So Commissioners, good news, number 2, that motion's been withdrawn, so we're not gonna hear it at all. So we're gonna hold on item Q right now, because number 2 has been withdrawn. We're gonna move on, unless Mr. Bloom's attorney's on there, and I'm gonna ask you to wave at me, Tamala, if she is.
they're not there yet.
Okay, thank you. And then we're gonna go on to contested cases. Okay, so, read this, is that okay with you, gentlemen?
Yes, sir.
Ms. Jennings, you good with that?
Yes, sir.
All right, anyway. Item J, contested cases, I think that's where we are.
Yes, sir.
If anyone has indicated they are appearing today in a case, staff has provided them with information on how to connect this meeting or bring them into the meeting when we announce the case. Right? Now, I don't think there's any respondents, is there?
Not that I know of, Mr. Chairman, unless.
Tamala, is there any respondents on the contested cases?
No, sir.
Okay, thank you, Ms. Tamala, I appreciate that. So I don't need to read this, so we'll go to the commissioners, we're just gonna hear from the prosecutors. If they're responding, some haven't pops up, I'll let you know. So we're on item J, number 1, commissioners. So, Funderburg, Mr. Funderburg's gonna be first up to bat, is
Yes,
that
sir.
correct?
He's right there on the screen.
All right, Cristobal Gonzalez, where are you at? There you go. All right, Mr. Funderburg, go ahead.
Thank you, Chairman, Commissioners. My name is Chris Vanderberg, prosecutor with enforcement. I'm presenting 3 cases consolidated into one SOA hearing tried in February 2021. Each case has its own complainant. All 3 are women. Each of these women allege that during the massage therapy session, the respondent engaged in sexual contact. Given the severe and serial nature of the respondent's conduct, in all 3 instances, the department sought the maximum relief authorized by law. Here, the department's enforcement plan places sexual contact into the penalty class reserved for the most serious violations, Class D. Class D has no sliding scale of penalties to allow for leeway based on the particular facts of a case. Instead, only one possible penalty exists, $5,000 per instance. Additionally, each instance of Class D serves as a separate basis for revocation. So at the hearing, we requested $5,000 in penalties for each instance of sexual contact, a total of $15,000. And the 3 Class D violations also provide the court and this commission with 3 independent bases to revoke the respondent's massage therapy license. At the hearing, the 3 complainants testified about their experience during their massage therapy session with the respondent, and afterwards, each witness was subjected to the respondent's cross-examination. The respondent also testified to his version of events and was cross-examined on the same. The ALJ heard all this testimony, and as presiding hearings examiner was also able to personally observe each witness's demeanor as they testified during direct on cross. The substance of their testimony, its internal consistency, and the witness's composure or lack thereof was all evidence the ALJ personally observed during this hearing, and all of this evidence informed the ALJ's determination on the most crucial fact issue in all 3 cases, Who do you believe? The ALJ's proposal for decision contains this answer, and it is unambiguous. In all three cases, the ALJs found the complainant's account of the massage therapy session more credible than the respondent's version. Having found the complainant's account as fact, the ALJ found sexual contact had occurred during each session, and that the severity of this violation authorized the maximum administrative penalty to be imposed on respondent, and also authorized the revocation of his license. We ask this commission to adopt the court's proposed decision. I'm happy to answer any questions you might have.
All right, is there any questions, Mr. Funderburg? Okay, I'll entertain a motion.
Make a motion to support the PFD.
Second that motion, Commissioner Collier.
All right, all those in favor say aye.
Aye.
Opposed? Stand down for a second. Thank you so much. Okay, hang on, guys, if you don't mind. Thank you so much. We're gonna go to the next case. Tam, I can't see Dr. Callis. I don't know if, Mike, if you can get that removed or not.
Move him into another.
Or slide him out, because I can't see his face, so purpose of his head camera. So that'd be great if we could do that, Mike. We're gonna go to number 2. Lurios and Ms. Prosecutor Hurtado.
Good morning,
Jessica, you there?
Commissioners. Yes.
Yeah, you're gonna have to speak up, Jessica, so we're gonna be able to hear you.
Good morning. Is that better?
That's better, yes. Go.
Okay. Jessica Hurtado. I'm a prosecutor in the Enforcement Division. I ask that you adopt the PFD as written and revoke Mr. Larios's journeyman and master electrician licenses. Respondent was licensed as a journeyman in 2014 and then as a master electrician in 2017. Then, in February 2019, respondent got into a verbal dispute with the manager of Chica's Cabaret, a bar where respondent was a patron. Respondent became verbally aggressive with security personnel who were clearing the bar for closing. After he was escorted outside, respondent had an opportunity to disengage. Instead, he made a deliberate choice to escalate the confrontation by getting a firearm from a vehicle outside the club. The respondent got into the passenger side of the vehicle, and as the vehicle drove past the security guards, he aimed the fire at them and fired multiple shots in their direction. The security personnel were able to positively identify the respondent as the shooter from a police photo display. As a result of this incident, respondent pled guilty to aggravated assault with a deadly weapon and was placed on 10 years deferred adjudication supervision. The respondent will remain on community supervision until March 2030. At the hearing, respondent testified that he was not the person who started the shooting, but he chose not to go to trial because of the cost and because he did not want to go to prison. Respondent testified he did not realize that accepting a deferred adjudication would affect his licenses. Respondent testified he has completed the required anger management courses and he provided numerous letters of recommendation on his behalf. Respondent has been on supervision for only 17 months and still has approximately 103 months remaining until he will be discharged. In analyzing the Chapter 53 factors, the ALJ notes that respondent has no other criminal history, actively runs his own electrical company, and is in compliance with the terms of his supervision, and provided letters of recommendation attesting to his character and work ethic. The ALJ considered that respondent was 30 years old at the time of the offense, which occurred approximately 2.5 years ago. However, the ALJ found that the serious nature of the respondent's offense should be given significant weight. The offense involved a verbal dispute, which respondent escalated by getting a gun and firing it at the club employees. The ALJ found that the respondent's testimony at the hearing indicated a lack of understanding of the serious risk respondent's actions posed to public safety. Finally, the ALJ considered the respondent still has approximately 9 years remaining on his supervision, and thus the ALJ concludes the department may consider respondent's deferred adjudication to be a conviction for licensing purposes. After considering all the evidence, the ALJ concludes that not enough time has passed for respondent to demonstrate his fitness to hold a license. Therefore, the ALJ recommends revocation of respondent's journeyman and master electrician licenses. I ask that you adopt the PFD as written, and I'm available to answer any questions. Thank you.
Okay, thank you, Mr. Hurtado. Any questions?
Ms.
And,
Hurtado, go ahead, Commissioner Collier.
Thank you. So Jessica, again, how many years has he been licensed, and aside from this incident here, any other violations or anything reported?
Yes, Commissioner, he obtained his journeyman in 2014, and then he became a master in 2017. And he doesn't have any other criminal history. I'm not aware of any program violations either.
Dr. Callis?
Ms. Hurtado answered my question. Thank you, Chairman.
Okay. Any other questions?
And is he online, or is there attorney online?
No, there's nobody here.
Okay.
Mr. Chairman,
Yes, sir.
Commissioner Callis, this is a hard one for me, and the reason it's a hard one for me because he's already proven that he was a journeyman. Then he went through all the education and to become a master electrician, but he's never had a criminal history. He's never had any problems with the law. But then he makes one bad choice, which is definitely an aggravated assault with a possibility he could have killed someone. It's kind of concerning to me, but I would like to talk to our counsel. What are our options? Because I think I really don't want to. I mean, I'm caught right now, and I just want to hear what our options are before I make my decision and vote.
Dr. Callis, this is Brad Bowman, General Counsel. So what's before you is the recommendation of the ALJ from the proposal for decision. So that's certainly one option, which is to revoke the license based on his criminal history. Depending on your view of the circumstances and all the factors here, there could be other options. I think this person would be eligible technically for a restricted license. This is an electrician case. And so it's one of the programs that's eligible for that license if the commission is comfortable granting a license, a restricted license in this kind of circumstance. And then there could be other depending on what you think is the appropriate remedy here.
Okay,
Right.
Commissioner Wesson.
Is there a possibility to do a suspension and then probate it?
Let me make sure he's currently licensed. He is.
Mr. Francis, did you have something?
Yes, I did. Mr. Chairman, this is Brian Francis, Executive Director of TDLR. Couple things to think about, Dr. Callis. If we go the restricted license avenue or path, that one typically requires that there's a supervising electrician or master electrician that's involved in it. He would be his own supervising master electrician. So I think the path that Commissioner Wesson, if that's something the commission is considering, may be the more appropriate one. It's saying that we trust you to do the work that you're doing, and if you make a mistake, we're going to take your license away from you at a later date. But the restricted one, I think it would be an abuse of that path, because I think it.
Your opinion.
Yes, sir.
Okay.
Thank you.
Commissioner Callis again. What I'm trying to do exactly what Commissioner Wesson was trying. I think what he was saying is that I don't think that a slap on the wrist in this regards is appropriate due to the fact that he brandished a firearm and he escalated it from a de-escalation where he could have walked out. My concern is I don't think he needs 103 more months in order to prove that he's a good citizen. He just had a bad day, probably with an altered mental state coming from that cabaret. That's my concern, is that I don't believe a restrictive license is appropriate here due to the fact that he'd be his own supervisor, but also too, I don't believe and for me, that I don't believe that keeping him unlicensed or suspending him for 103 months is appropriate either. So that's where I'm having a hard time right now.
Okay, they got your opinion, Mr. Bowman.
And yes, Mr. Chairman, and that he is currently licensed. He holds a journeyman and a master license. So you could suspend the license, both licenses, probate them for a period of time. We need to decide what period of time you think is appropriate. Is it 1 year? Is it 2 years? And then establish some conditions for that, like we've done in other cases. So standard terms and conditions. He has to comply with any criminal probation terms, with laws and rules of the department. So the main thing I think to decide is how long a period of time, if this is the direction that the commission wants to go.
Right. And Brad.
Hang on, Commissioner, hang on. I just want to make sure that you understand what the motion is, right? Questions? Okay, all right. Go ahead, Commissioner Kaiser.
Yeah, I just wanted to know, when do those two licenses renew?
Go ahead, Commissioner Kaiser.
Yeah, when do those, Brad, when do those two licenses are set to renew?
I may have to look to the prosecutor here. Jessica, do you have that information handy by any chance? If not, we can.
Sorry, the licenses are currently expired, but he can renew them.
Mm.
I want to remind the commissioners, we don't have representation on his side here, so just for the record. Okay, any other comments?
Mr. Chairman.
Yes, sir.
Brian Francis. Commissioner Collier, keep in mind that with our, under Chapter 51, a person can late renew up to 3 years. So the fact that it's expired now is not an issue. You guys can make the decision to allow them to renew one or both of them. You could suspend the license and then probate it as Brad had laid out. That's an option that would accomplish what I think Dr. Callis wanted, and obviously accomplish what Commissioner Wesson was identifying as well.
All right, any further discussion? Okay, I entertain a motion.
I'll make a motion that we suspend the licenses, but probate it for 12 months.
Okay, is there a second to that motion?
Can Commissioner Wesson clarify what he considers 12 months? 12 months from today, 12 months from, can you be more specific?
Well, let's do it from 12 months from when he renews it.
12 months from renewal.
Because it's expired at this point.
Well, I would say he can't renew it right now. It's expired right now. So would you say 12 months from today? Or would you say, because he, like Mr. Bowman just said, we got 3 years, he can renew his license?
I think it would, this is Brad Bowman, I would recommend that it start when he renews and when the
when he renews his license.
Whenever he decides to renew that license, Dr. Callis, is when the 12 months starts.
Thank you, sir. I just want a clarification.
Okay, good point. Commissioner Butler?
Yeah, I'd like to ask, my internet went out for a few minutes and I was able to get back on. And so this may have been addressed, and please forgive me if it has been. Has anyone talked about a fine or anything for this gentleman if he were to get his license back? Was that mentioned at all?
No, we did not ask for any kind of penalty.
Say that again.
We don't typically ask for a penalty in this type of a case, so we didn't seek any penalty.
Okay.
Commissioner Callis, I'll second Commissioner Wesson's motion.
Okay, so we got a motion, we got a second. Any further discussion or questions on that motion?
I guess with that, this Commissioner Collier was he taking any type of I think it was mentioned about anger management classes, anything along that lines? Would there be any combining of that and any openness to that, Dr. Callis or Dr. Wesson?
I
think the motion stands. Are you offering a friendly amendment, Commissioner Collier? Is that what you're asking for?
That's a friendly amendment. Thank you.
Okay.
I'll accept.
What's your friendly amendment?
Yeah. So if a part of what he was doing already was taking anger management classes, that those classes are continue within that 12-month time period.
after
If-
renewal.
Correct.
Commissioner
I'll
Callis.
amend my motion.
Okay, stand by here. I want to make sure, because I'm confused. I want to make sure I understand. So you want to add the amendment of what?
Anger management during that 12-month probation.
Is that possible, Mr. Bowman?
I think the only issue might be enforcement of that or
Right.
verification of that. I mean, I think it's a reasonable term for the commission to order. I think that's the question, is whether the monitoring of and the enforcement of that is practical.
You understand the challenge, Commissioner Kaiser?
Understand the challenge.
The monitoring and enforcement was for Mr. Bowman. You still want to add that amendment?
Go ahead, Dr. Callis.
I would recommend, so we're not complicating the matter. I totally agree with Commissioner Collier. I say what we do as a commission is that we put it on him so it doesn't have to be monitored and by enforcement. And then whenever he comes back for relicensure, we see if he's taken his own steps to try to improve his anger management on his own without us putting it in enforcement. And I think that would still solve the issue to where you can look and see if Mr. Larios, whenever he's up for renewal in 12 months, if he's done nothing, then I think we look at that and say, hey, you're not really serious about getting this license back based on Commissioner Collier's comments.
Mr. Chairman, may I?
Yeah.
Brian Francis, Executive Director with TDLR. Commissioners, one of the things that we include in all the restricted license agreements is we include a provision that says they must continue to be in compliance with their probationary status and requirements there. And I think that would be appropriate here because the anger management is tied to that as well as the courses. And so we can have Jessica use that language that says will remain in compliance with probationary status and will notify us if they're out of compliance with that. And then that could trigger the suspension.
Are you good with that, Commissioner Collier?
Yep, I'm good with that.
Commissioner West? Good with that. All right, so we'll amend that motion with that contingent. All right, you good with that, Dr. Callis? Okay, good. Got a motion, got a second. Any other questions? All right, all those in favor say aye.
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 Opposed? All right, motion carried. All right, Mr. Smith, Huber Smith, Mrs. Furtado. Item number 3.
Jessica Hurtado, Enforcement Division. I ask that you adopt the PFD as written and deny Mr. Smith's application for an incident management tow operator license and tow company certificate. Mr. Smith's criminal history is extensive. In 1993, he was convicted of misdemeanor assault. Then in 2011, he was convicted of possession of a controlled substance, in this case cocaine, from 4 to 200 grams of felony offense. Mr. Smith was sentenced to 3.5 years in prison. Then in 2013, the applicant was again convicted of felony possession of a controlled substance. He was in possession of cocaine and was sentenced to 3 years in prison. In 2017, the applicant was convicted of 2 felony possessions of a controlled substance with intent to deliver offenses. Mr. Smith was in possession of 200 to 400 grams of codeine as well as cocaine. The applicant was sentenced to 8 years in prison. He was released from prison in February 2020, and he will remain on parole until May 2025. Mr. Smith admitted on his criminal history questionnaire submitted to the department that he was selling drugs in order to make money. He testified that he's paid for his crimes and he's trying to live as a law-abiding citizen. The ALJ concludes that Mr. Smith's drug offenses are directly related to the duties and responsibilities of a tow truck operator and tow company, because holding these licenses would provide an opportunity to continue selling drugs and pose a threat to public safety. Operating a tow truck or a tow truck company would provide the applicant with an effective cover to buy, sell, or distribute drugs. The ALJ notes that Mr. Smith's drug offenses occurred when he was an adult, from the ages of 35 to 40 years old, and that he has been out of prison for approximately 18 months. The applicant offered no evidence of rehabilitation or letters of recommendation to support his fitness for licensure. Therefore, the ALJ concludes that Mr. Smith has not shown himself to be fit for licensure at this time. The ALJ recommends denial of Mr. Smith's license application. I ask that you adopt the PFD as written, and I am available to answer any questions. Thank you.
Thanks, Ms. Hurtado. Any questions?
No questions on my end. Commissioner Collier moves to adopt the PFD as written.
Second. Commissioner
I got a
Callis,
mo-
second.
Second. No other questions from any other commissioners? All right, all those in favor say aye.
Aye.
Opposed? All right, motion carries. Thank you. Mr. Hurtado, Ms. Phillips.
Jessica Hurtado, Enforcement Division. The ALJ recommends that you deny Garrett Paul Phillips cosmetology operator renewal application and revoke his license. In 2012, respondent was issued a cosmetology operator license. Then in March 2016, he became involved in an altercation with the victim, his friend, whom respondent accused of stealing his wallet. During the altercation, respondent struck the victim in the back of the head with a pistol, as well as in the ribs and temple. Mr. Phillips threatened to kill the victim and warned him not to call the police. As a result of this incident, respondent pled guilty to aggravated assault with a deadly weapon and was placed on deferred adjudication community supervision for 2 years. In 2018, respondent applied to renew his license. The department took a chance on Mr. Phillips and renewed his license despite his 2016 offense. Then in 2019, Mr. Phillips again pled guilty to aggravated assault with a deadly weapon. Respondent again received deferred adjudication supervision for 2 years. According to the victim, she was walking to the bus stop with her children past respondent's apartment. Mr. Phillips was outside and became angry because he believed her son was yelling at him. Mr. Phillips threatened to shoot the child and began an argument with the victim. Respondent then made a deliberate choice to escalate the argument. He retrieved a pistol from his apartment and fired 2 shots at the victim and her children before retreating inside. The victim called police, who located 1 shell casing inside the apartment near the front door, consistent with someone firing from inside. In his criminal history questionnaire, respondent stated that he was attacked and believed that his life was in danger. However, respondent did not give any testimony at the hearing regarding either offense. Mr. Phillips was discharged from supervision in May 2021. In analyzing the Chapter 53 factors, the ALJ notes that respondent was still on community supervision for his first offense when the second offense occurred in 2018. The ALJ notes that respondent's second offense was especially concerning because it involved a disproportionate response to the behavior of a child. The ALJ concludes that such a response calls into question how respondent may react if confronted with a similar situation while working as a cosmetologist. Additionally, the ALJ notes that Mr. Phillips was 25 years old at the time of his first offense, and he was 28 years old at the time of his most recent offense. Respondent was an adult, and these offenses were not mere acts of youthful indiscretion. Finally, the ALJ notes that Mr. Phillips provided no evidence to demonstrate his conduct or work activity or any letters of recommendation. Although his successful completion of his community supervision weighs in his favor, the ALJ concludes that Mr. Phillips may pose a threat to public safety. Therefore, the respondent's deferred offenses may be treated as convictions for licensing purposes. The ALJ concludes that respondent's renewal application should be denied and his license should be revoked. I ask that you adopt the PFD as written, and I'm happy to answer your questions. Thank you.
Any questions, Mr. Hurtado?
No questions. Commissioner Collier so moves to adopt the PFD as written.
Commissioner Callis, second.
All right, any further comments? All those in favor say aye.
Aye.
Opposed? All right, motion carries on number 5, is that correct? Is that correct, Mr. Hurtado, number 5?
That was 3.
Smith?
That was Mr. Phillips.
That was Phillips number
I'm
4.
sorry, yeah, Mr. Phillips,
We're now on 5.
5, yeah, on number 5. Ms. Smith, go ahead, Mr. Hurtado.
Jessica Hurtado, Enforcement Division. The ALJ recommends that you revoke Galen R. Smith's ACR contractor license. Respondent obtained his license in 2010 and most recently renewed in 2018. On his renewal application, Mr. Smith falsely answered no to the criminal history question. Based on his answer, the department renewed his license before learning about his criminal history. In 2017, Mr. Smith confronted a tow truck operator who was at his home in order to repossess respondent's vehicle. Mr. Smith approached the tow truck operator while holding a pistol and told him to drop the vehicle. When the operator refused, respondent entered the tow truck and dropped the vehicle himself, causing damage to the truck. Mr. Smith then returned to his home, retrieved a rifle, and again went outside. According to the tow truck operator, respondent also pushed him and tossed the tow truck's keys into a nearby field. Respondent admitted to the police that he had a rifle and a pistol out during the dispute, but denied pointing them at the tow truck operator. Mr. Smith also denied assaulting the operator, but admitted he did toss the keys into a field. As a result, Mr. Smith pled guilty and was placed on deferred adjudication supervision for aggravated assault with a deadly weapon for a period of 4 years. Mr. Smith testified at the hearing that he accepted the plea bargain under duress because prosecutors were pressing fraudulent felony charges against his wife and son. However, respondent's plea has not been challenged on appeal and remains valid despite these claims. Respondent testified that his 17-year-old daughter is in charge of running his business, and her job duties include renewing his license. Mr. Smith also testified that he was not in compliance with his supervision because he left the state in order to move his mother to Texas due to her ill health. Finally, Mr. Smith testified that due to the nature of his business, a restricted license is not a feasible option for him. The ALJ considered that respondent was 38 years old when the offense occurred less than 4 years ago. The ALJ found the offense was serious in nature, and because disputes may arise from interacting with the public as a licensed ACR contractor, there is opportunity for respondent to commit similar offenses in the future. Additionally, respondent provided no evidence that he is currently in compliance with the terms of his supervision or any letters of recommendation from individuals who could vouch for his character. Therefore, the ALJ concluded that respondent failed to establish he is fit to discharge the duties and responsibilities of an ACR contractor and recommends revocation of Mr. Smith's license. I ask that you adopt the PFD as written, and I am available to answer your questions. Thank you.
Any questions, Mr. Todd? All right. I'll entertain a motion.
Make the motion to accept the PFD as written.
Is there a second?
Commissioner Callis, second.
All right. All those in favor say aye.
Aye.
All right, opposed? Motion carries. Mr. Todd, one more. Ms. Glenn. Mr. Glenn. Go ahead, Mr. Todd.
Jessica Hurtado, Enforcement Division. The ALJ recommends that you deny Jasmine Glenn's application to renew his apprentice electrician license and revoke that license. Respondent obtained his license in 2016 and sought to renew his license in March 2020. On his renewal application, Mr. Glenn falsely answered no to the criminal history question. Respondent had previously pled guilty to burglary of a habitation, a felony. In January 2020, he was placed on deferred adjudication supervision for 2 years, ending in January 2022. In 2019, the victim discovered that Mr. Glenn had entered his garage and taken a tool bag containing 2 drills and other accessories. The victim learned of the offense after he reviewed surveillance video of his home. The victim reported the theft to police, who identified the license plate of the vehicle, which was registered to respondent. At the hearing, Mr. Glenn denied that he had committed the offense and stated he was not thinking about his supervision when he submitted his renewal application. However, he declined to offer any sworn testimony or any other evidence to support his argument. The respondent's offense is directly related to the duties and responsibilities of a licensed electrician. Respondent entered a garage where unattended property was located and took it without permission. This is precisely the type of scenario that is concerning because electricians often come in contact with unattended property. Therefore, allowing respondent to retain his license will afford him the opportunity to commit similar offenses in the future. The ALJ concluded that respondent's explanation for the false answer on his renewal application was questionable, given that his plea was completed only 2 months prior to his renewal. After considering that Mr. Glenn was 29 years old at the time of the offense, the amount of time that had elapsed since the offense occurred, and the lack of evidence supporting respondent's fitness for licensure, and concluding that regarding the false answer on his renewal application, the ALJ recommends that respondent's license renewal be denied and his license be revoked. I ask that you adopt the PFD as written, and I'm available to answer your questions.
All right, Mr. Hurtado, thank you so much. Is there any questions, Mr. Hurtado?
No questions.
Mr. Chairman, this is Brad Bowman.
Yeah, hang on. Yeah, yes, sir.
Just really quick, there's one technical correction in finding of fact number 1 that we would recommend, just correcting a typo.
Okay. We have a technical correction of fact and finding number 1, so you make a motion that needs to be added to it.
Commissioner Collier moves that we adopt a PFD as is, as written, and then include the correction of the typo for fact finding number 1. Is that correct?
Yeah,
Commissioner
yes,
Callis, I
that's correct.
second.
All right, we got a motion, got a second. Any further discussion? All right, all those in favor say aye.
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 Opposed? All right, Mr. Tata, thank you so much. Extraordinary effort. Appreciate it. All right, I'm gonna reset here just for a little bit. We're gonna go back to motion for rehearing. I'm gonna let Tamala get a minute to get the attorney on the line and Ms. Bloom back. Our guest, if you want to speak, you're welcome to speak. I know it's kind of a crazy day. We always live in crazy day worlds. Please feel comfortable, fill the form out. We'll try to get to you as much as we can, okay? Appreciate you guys being here. So Ms. Tamala, is Ms. Bloom and her attorney on the line?
Yes, sir. They are in the meeting now.
Okay. Ms. Bloom, you there? Ms. Bloom?
Her attorney, Betty Smith, is in the meeting.
Okay, Ms. Smith, are you there?
Yes, sir.
Ms. Smith?
Can you hear me? Are you able to hear me?
I'm here.
Okay, Ms. Smith, can you turn your camera on, please?
Is mine not on?
All right, thank you, Ms. Smith. I'm Chairman Figueroa, welcome. Listen, I appreciate your latitude. Apologize for we're going through this agenda as much as we can. We've got a commissioner who's not feeling well, so we're gonna try to get through everything. So we're gonna do motions with the hearing. Is Ms. Bloom gonna be participating? Is she anywhere? Am I missing her?
I'm here.
I can see her in the room.
Okay, I can't see Ms. Bloom. Am I missing her? Here. Okay, all right, Ms. Smith, we're just gonna go with you. I'm gonna read you these instructions. Let me know if you have any questions, okay? We'll hear from the general counsel first, and then from you. You'll have the opportunity to speak. Make sure you speak clearly and say your name and who you represent. This is a motion for rehearing, which means there has already been a decision made, in your case. So we're not here today to re-argue the case. This is an opportunity for you to tell us how we have made an error in entering the decision against you. You'll be limited to speaking to those issues that are raised in your motions for rehearing. The Assistant General Counsel and you will have each 5 minutes to speak, and then we may have a 3-minute follow-up. Ms. Smith, you understand what I just read you?
Yes, sir.
Perfect. Okay. And I think Mr. Jennings, did you move on? There you are.
Yes, sir.
Mr. Jennings, all right. Commissioners, Mr. Butler, are you still there? Stand by.
Yes, Chairman. I've been here this whole time.
Okay. I want to make sure I got you, Mr. Collins. Got to make sure I see your faces. Okay. Mr. Jennings, you on?
All right, thank you, Chairman. Doug Jennings, Assistant General Counsel. This matter resulted from an order in which the commission revoked the respondent's massage therapist license based on the respondent's statutory ineligibility for the license for a prior deferred adjudication for the offense of public lewdness. I will keep my comments brief. In essence, section 455.152 of the Occupations Code makes the respondent permanently ineligible if he or she has been convicted of, entered a plea of no contest or guilty to, or received deferred adjudication for an offense under Chapter 20A of the Penal Code, Subchapter A of Chapter 43 of the Penal Code, or another sexual offense. The charge of lewd conduct qualifies as a sexual offense under the Penal Code. This is not the first time we've looked at this issue. I believe the commission has taken the guidance of the Office of General Counsel that the statute simply does not permit the department to grant a license in this scenario. We have consulted with the Office of the Attorney General to confirm our understanding of the law, and once again, that was affirmed. So I will stop there. I just simply would ask that you deny the motion for rehearing on the basis that the department does not have statutory authority to grant the application.
Okay. All right, Ms. Smith, you there?
Yes, can you hear me?
Okay, you're gonna have to speak up just a tad, please, if you don't mind.
I'm sorry, I'm not sure exactly where my mic is, so is that better?
You're gonna have to give a little bit more. We're old people, so we're gonna have to read into it here.
I understand. I apologize. I'll do my best.
We'll give you a second. We'll give you a second here, Ms. Smith. Don't worry. Commissioner Callis, can you hear her?
Thumbs up.
Okay. Commissioner Butler, can you hear her?
Mr. Chairman, I can.
You can't? Okay.
Yeah,
Ms.
I
Smith,
can
just a
hear
little
you.
louder, please.
I can hear you. Yes, sir.
Let's try again, Ms. Smith. Go ahead.
All right, how's that?
We'll get by. Go ahead, Ms. Smith.
Is that better? All right, I'll turn up the volume just a little bit. Like I said, I apologize. Not exactly sure where my mic is on these. Good morning, and thank you to the commission members today. I'm going to keep it short. It's our position that the former iteration of Occupations Code 455-152 should apply in this case, making a licensee eligible.
Ms. Smith, we can't hear you. I'm not sure what the situation is, but we can't hear you right now. I'm not sure if we didn't get you tested or for the, Mr. Mike, can you help her or can you help us hear that volume better? Is that possible? Dr. Callis, can you hear her clearly? Is it just us? You can't hear her either. Okay.
Does she have a headset or anything she can plug in?
I don't have
Okay,
a mic.
that's perfect. All right, Ms. Smith, go ahead. Go ahead. Start over if you don't mind, please. Now you're here. He cranked it up. Go ahead.
Okay, great. All right. Thank you to the commission members. Appreciate y'all being here today. It's our position that the former iteration of Occupations Code 455-152 would apply in this case, making Ms. Bloom eligible for a license after 5 years. In the alternative, we also believe that the state should be stopped from revoking her license under the case law of Bosley versus HHSC. The Supreme Court has ruled that a state agency, if it had given a licensee an affirmative misrepresentation about the administrative process, would then be stopped from revoking the license. And in this case, Ms. Bloom had submitted a criminal history determination under Chapter 53, had been granted the license, and then had her license renewed more than once, all the while the government was aware of her criminal history. And we believe that revoking her license at this stage goes against the traditional notions of fair play that the government should be invested in upholding. And that's all we have. Thank you.
Ms. Smith, thank you. Again, we apologize for technical difficulties. Any questions, commissioners, on this?
This is Commissioner Collier, and I'm sorry I can't see our attorney. So, can't see him. So my question is, I guess when it was renewed, I can't see our attorney. So Brad, if you can refer to our attorney. When it was renewed, I'm assuming it was renewed under the prior agency. Is that correct? For the license.
Commissioner Collier, this is Doug Jennings, Assistant
Thanks,
General
Doug.
Counsel.
Yeah.
Yes,
Thanks, Doug.
I-
I'm not seeing you. Yeah.
My understanding is that the respondent was initially issued the license by the Department of State Health Services, and that that license was renewed several times. Once the massage therapist program was transferred to TDLR, the first time that that license came up for renewal, the respondent renewed with TDLR, and that's when we did the background check and discovered this prior offense.
It was renewed, the license was renewed once by TDLR. It was the second time the license was up for renewal through TDLR that it was revoked.
No. No, that's incorrect.
I don't even know who's speaking right now.
Joseph Bloom.
Okay. Now, is that, which is correct, Mr. Jennings?
I'd like to hear from Ms. Bloom, if that's okay.
Ms. Bloom, go
Correct.
ahead and speak.
Oh.
Ms. Bloom, we
Brandon,
can't hear you. We can't hear you, Ms. Bloom. Ms. Bloom, say something, give me a test.
Yeah, so I've had my license initially from the health department. It was reviewed once through the health department, and then can you hear me now?
Commissioner Callis, I can't hear and understand.
All right.
Hello, can you hear me now?
Hey, Miss Bloom, this is Commissioner Callis. Try turning off your video and seeing if you can just speak, and that might take your.
Hello, yeah, can you hear me now?
Try, okay, hang on. Everybody go on mute. Ms. Bloom, just
Okay, so it was renewed once through the health department, and then renewed once through the TDLR. This was my second time to get it renewed through the TDLR.
Okay, so did you get that, Mr. Jennings?
I did.
My second time.
Okay, hang on, Ms. Bloom. Just give me a sec. Keep your picture off and at least hear you.
Okay.
Go ahead.
Can you hear me now?
Yes, we got you. Just put yourself on mute. Give me a second, Ms. Bloom. Go ahead.
Can you hear me now? How about
Ms. Bloom?
now?
We can hear
Hello?
you. We can hear you. Stand by, Ms. Bloom. Can you hear me, Ms. Bloom?
Can you hear me now? Hello? 1, 2.
I'm in a bad commercial here. Ms. Bloom. Ms. Bloom, can you hear me?
Thank you. Okay, good.
Okay. Ms.
Okay.
Jennings, did you get that? You once under.
Yes.
Chair, I did.
Okay, thank you.
What I'm seeing from the record simply is that her license was issued in June 2014
I can?
by DSHS. And
I
that
know.
she applied to renew her
Yes.
license with TDLR.
Yes, I can hear you.
2020.
I think there's a delay.
What are we doing here?
Just hang on, commissioners. Stand by. Ms. Bloom, can you hear me? Is Tamla talking to her?
She has a delay, Mr. Chairman.
Okay, so
she's hearing you late.
Okay.
Responding to you late.
Okay, so Ms. Smith, if you can text your client and tell her we're working on it.
28. Yes.
Give us.
Yes, I can, sir.
Okay. And just tell her, be on mute for a second. If she can communicate through you, that'd be great. Just give me a second here. Okay? Mr. Jennings, go ahead.
Chairman, it may have been that the issue was first licensed by TDLR. Perhaps one of the renewal licenses was granted by TDLR. I don't have that on the record before me. I know that the massage program was in transition from another state agency, and there may have been a scenario where licenses were granted without a full background check. It is not something that has come to my attention that we were aware of the prior offense, the deferred adjudication for lewd conduct, and granted a license renewal with knowledge of that.
Right. Okay.
So the first time, it's my understanding that, and we discussed this at the hearing where we considered the PFD, when we became aware of the deferred adjudication for lewd conduct, we were aware that Section 455, 152 required us to deny that renewal application and to revoke an existing license based on Chapter 455.
Commissioner, I want to remind you of the statute that's enforced right now. So I understand you have some questions, but unless Counselor, which is either Brad or Mr. Jennings, Bowman Jennings, advises otherwise, I understand where we are. Okay, so Want to make sure. Ms. Smith, are you communicating with Ms. Bloom?
Yes, sir.
Okay, tell her we're doing the best we can. Make sure she gets her voice heard. Is there any other comments, Ms. Smith, that you need to communicate for you and your client towards us in response to this?
The only other thing I would say was that when the initial license was granted, she, along with her criminal history determination request, submitted certified copies of the court records from her criminal case per the instructions provided to her.
Okay. I have a quick question, Mr. Bowman or Mr. Jennings. The statutes that Ms. Smith recited, have we factored those in our decisions?
Chairman Doug Jennings, Assistant General Counsel. Yes, we have. And the statute that Respondents Counsel cited would be former subsection 455 152B. That section no longer exists, but it states, and I have it, it stated that a person convicted of a violation of this chapter is ineligible for a license as a massage establishment, massage school, massage therapist, or massage therapy instructor until the 5th anniversary of the date of conviction. However, Ms. Bloom was not convicted of a violation of Chapter 455 of the Occupations Code. The statute clearly says a person convicted of a violation of this chapter is ineligible and then has the 5-year safe harbor period. Ms. Bloom pleaded no contest to and was placed on deferred adjudication for an offense under another chapter, and that would be of the penal code. So we believe this section, this language is not applicable in the case before us.
Okay, that clears it up. Any other questions?
Yes, Mr. Chairman, Commissioner Callis, I have a question.
Go ahead.
Miss Smith, is this your client's only offense for lewd or acts like this ever in her life?
Yes, sir. This is my client's only criminal history ever.
And can you repeat to me when this happened?
1995.
1995. I just want to be very clear. It happened in 1995, and this is 2021, and she's been working under a license until she got switched over to TDLR. Is that correct?
Yes, sir.
Okay, that's all my question. Mr. Chairman, I have a problem with this, just to let you know. If she's only had one criminal act in 1995, which is more than 20 years ago, and we're holding her hostage because of some code, I have a problem with this. Whenever she has more restriction on her based on a code than someone that almost killed somebody. And it makes no sense to me, just to put my voice out there.
Dr. Callis, I couldn't agree with you more, but it's a statute in the sense that we have restraints within what we are capable of doing. Now, we have seen cases like that, stand by. We have seen cases like this come through. We've assigned Executive Director Francis and Mr. Bowman to see what we could do as far as work around, because the commission as a body has voiced that similar sentiment that you have just stated with vigor and enthusiasm as much as you have. So I am not aware of any workaround on this. So I understand what you're saying, but in the same vein, unless I can be updated currently, Mr. Francis, do you have any updates that I'm not aware of?
Mr. Chairman, right now, we don't have any updates, and I don't want to abbreviate the decision that's happening here. Because any updates we have, we'll be able to apply those accordingly. So I think it would be inappropriate to interject at this point in time. I will say, though, that there's an opportunity, and this provides a path for Ms. Bloom and her attorney to go to district court and have the courts rule on this. That's all. The denial of the motion for rehearing will allow her the ability to go to district court.
Right.
And maybe that's who needs to referee this moment.
Right, I concur. Commissioners, you understand what Mr. Francis is communicating to you guys about that?
If you can clarify that, if you can expound on that, Commissioner Collier's request.
It's basically the denial of the rehearing alleviates them from having to come back to us, and they go directly to district court to appeal this decision to district court, let them decide on the statute and if there's an out for this. Okay? That make sense?
Got it. Clear on having to spend additional money in order to get a decision on this. I'm clear. Thank you.
Hey, we could pontificate all day long. Hey, Mr. Bowman, is there anything else on this?
No, sir, I think that covers
Mr.
it.
Jennings?
No, sir.
All right. Ms. Smith, I'm giving a lot of latitude to this. You have any more comments? All right, Commissioner. Yes,
Oh,
ma'am?
I'm sorry, just one thing, there was a House bill up this past session to change this statute. It unfortunately had been, after being placed on the local and consent calendar, died in the other chamber, as a result of what I believe to be partisan politics. Hopefully the next time it comes up, I would hope to see all of you there in support of changing this law.
Ms. Smith, I don't think you have more friendly advocates for that in this institution, so be aware of that. I'll entertain a motion if we don't have any more comment, commissioners.
Yeah, this is Commissioner Collier. Understand the statute that's dictating the motion. I do echo Dr. Callis's comments. 1995 to 2021. So definitely want to be on record in that regard. Commissioner Collier moves to accept the motion as is, knowing that we're tied by statutes.
You mean deny the hearing?
Deny. Thank you. So deny the rehearing. Sorry about that.
I'll second it.
Second. We got a motion. We got a second. All in favor, say aye.
Mr. Chairman, I want to go on record, just like Commissioner Collier did. I think this is completely unnecessary. I think if we're going to rehabilitate people in the state, I think it's kind of very concerning to me that we take this and move this up as fast as we can, due to the fact she has done everything she possibly could do, made a mistake, and now she's not getting denied a motion for rehearing. I just want to go on record, but I will support the denial. But I do agree it's going to cost the clients a lot more money when we should be able to do this in-house.
That's the longest I have ever heard in my life, but God love you for it. I agree with you.
Sorry, sir, but I'm very passionate about this. This is completely not correct in my eyes.
Yeah, I would concur with that as well. This one.
I cannot. I'm unvoiced. All those ayes. Tom, Mr. Butler, you good?
I concur with everybody here. This is it seems like it's rather an unfair thing. I wish there was something we could do.
All right. Any nays? All right, motion carries. Ms. Smith, you've heard our heart. Ms. Bloom, you've heard our heart, and hopefully we can figure this out. Stay the course, and we'll lean into it as much as what Mr. Francis said earlier. We're not gonna, as we work through this, we'll keep you posted on our movement on our side, okay?
Thank you very much.
Thank you, Ms. Smith. Thank you, Ms. Bloom.
Thank you, commissioners.
Okay, all right. We are going to go to rules. Is that right, Mr. Bowman?
Yes, sir.
Okay, we're going to rules, commissioners. Item K, Jessica. Where are you? There you are. Okay, all right. Hey, wait, before we do that, Jessica, give me a second. Mr. Butler, how are you feeling? You okay?
I'm good, Mr. Chairman. I'm good. Thank you.
All right, Commissioner Collier, I know time constraints. Are you dropping off? Or are you able to stay on board?
Just a few more minutes. So let's continue as quickly as we've been rolling. I appreciate it, because I'll be hopping off. I got 5 minutes or so. Let's proceed.
Okay. Just if Mr. Butler, if you wane on us, let us know. We're gonna lose Commissioner Collier in a minute. Miss Jessica, go ahead.
Good morning, Chairman and members. I'll be presenting Administrative Code Rules at Chapter 97 for motor fuel metering and quality. While a permanent motor fuel board was created during this last legislative session, we still don't have a permanent board for this group yet, so there were no rules presented to an advisory board, but we did work with industry in preparing these rules. The rules are necessary to implement House Bill 2106 from the 87th legislative session related to credit card skimmers, and they reconcile the amended statute and current department rules. The rules were filed with the Texas Register for public comment and published on August 6th. We received one comment, but it was not directly related to the proposed rules. We did refer it to staff for consideration, and changes were not made to the proposal as a result of that one comment. Commissioners, I'm asking that these rules be adopted with an effective date of November 1st, and I'm available for questions.
Thank you, Jessica. I appreciate it.
Yes.
Any questions?
And Commissioner Collier moves that we adopt the motor fuels as presented rules.
Second.
All right, got a motion, got a second. All in favor, say aye.
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 Opposed? All right, motion carries. Thank you, Jessica, so much.
Thanks, have a good morning.
Item L, Mr. Gladney, where are you at? There you are. You have the floor, sir.
Good morning, Commissioners. I'm here to present the proposed rule that increases the allowable VSF impoundment fee and daily storage fees in accordance with changes in the CPI during the preceding state fiscal biennium. This proposed rule increases the maximum allowable vehicle storage impoundment fee and daily storage fees that can be charged by VSF in accordance with changes for the CPI. Pursuant to Occupations Code 2303.1552, the Commission is authorized to adjust the vehicle impoundment and storage fees based on changes in the CPI not later than November 1st for every odd-numbered year. The rule was put out for public comment and published on August 13th of this year. The public comment period closed on September 13th. We received 7 comments during that period, none of which changed the published rule. The Towing and Storage Advisory Board met on September 15th to discuss the proposed rules and the public comments received and recommended adopting the proposed rules as published. The department is asking to adopt the proposed rules as published with an effective date of November 21st, 2021.
Any questions for Mr. Gladney?
So moved.
Yeah, and second, Mr. Gladney, that was based on this Commissioner Collier, and I agree. I don't have any opposition. That was based on the 5.4% CPI. If you say in the biennial, can you pronounce the word? Disregard. I'll take a look at it. Thank you so much. I agree. Aye.
Okay, we haven't voted yet. Hang on. Is there any other questions? All right, we got a motion, got a second. All those in favor say aye.
Aye.
Any opposed? All right, motion carries. Item M, Mr. Gladney.
Mark Gladney, General Counsel's Office. This rule package is the proposed amendments that pursuant to Occupations Code 2308.0575 that address the maximum amounts for private property tow fees and drop charges that can be charged by a towing company. Pursuant to the statute, the department contracted for a fee study employing the mandated factors within the statute, and the maximums for tow fees and drop charges were increased as a result. The proposed rule is based upon findings from this 2020 fee study, which examined the statutory factors, economic factors for the period from 2015 to 2020, and is necessary to comply with the statutory requirements in order to protect public health and safety of consumers. The proposed rules were published on August 13th. Public comment closed 1 month later, September 13th. We received 4 comments during the 30-day comment period, none of which changed the published rules. The advisory board met on September 15th to discuss the proposed rules and public comments and recommended adopting the proposed rules as published. The department's recommendation is adopt the proposed rules as published with an effective date of November 1st, 2021.
Any questions for Mr. Gladney? All right, entertain a motion.
So move with the effective date being November 1st, 2021.
And second by Commissioner Callis.
All right, all those in favor say aye.
Aye. All right.
Opposed?
No opposition. Hey, Mr. Chairman, I'm going to have to hop off.
All right, have a good day, Commissioner Collier. Thanks so much
guys.
for your effort.
All
Thank
good.
you so
Thank
much,
you.
Mr. Collier. Be safe.
All right, we're on item N.
Hello,
Mr.
board
Fitz.
members or commission members. My name is Alex Phipps, and I'm here to present the package of repeals for Chapter 88 of the agency's rules. Just to give you some background on this package, this is a complete repeal of Chapter 88. This is the Polygraph Examiners Program. These proposed repeals implement the changes from House Bill 1560, the department's Sunset Bill. That bill deregulated the polygraph examiner program by repealing Chapter 1703 of the Occupations Code effective September 1st, 2021. It also abolished the Polygraph Advisory Committee. So the department put forward this package, proposed it without any comment from the advisory committee since it was being abolished. We received one comment on this proposed repeal. That proposed comment actually expressed some dissatisfaction with the actions of the legislature in deregulating this program. That comment's outside the scope of the proposed rules since it concerns legislative decision-making by elected representatives. So the department made no changes as a result of that comment. So staff is recommending that you adopt the repeals of Chapter 88 and deregulate the polygraph examiners program. And I'm happy to answer any questions you may have.
Any question for Mr. Phipps? I'll take a motion.
Make a motion to adopt.
There's a second. All those in favor say aye.
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 Opposed? All right, motion carries.
Thank you, Commission members.
Thank you, Mr. Phipps. Item O, Mr. Jennings.
Yes, thank you, Chairman. Thank you, Commission members. Doug Jennings, Assistant General Counsel. I'd like, with your leave, Chairman, I'd like to combine items O and P.
I would love nothing better.
Thank you. If you have a sense of deja vu, that is because this is the third time this rule package has come before this commission. The first time earlier in the year, the commission adopted these rules as an emergency rulemaking. Later on in August, the commission voted to extend the timeline, extend the effectiveness of the emergency rules. The rules, as you will recall, before you, delay the effectiveness of Section 210.8F of the 2020 National Electrical Code. That is the provision that requires certain outdoor outlets to have a ground fault circuit interrupter. And it has come to light that that equipment is causing air conditioning compressors to fail. And also furnaces posing a threat because of the summer heat. And later, as we approach winter, threatening the safety of Texans who are trying to heat their homes. If that equipment fails, we know that the extremes of Texas weather can pose a real danger to people's safety. As promised, we have kept tabs with this issue. Our program experts have confirmed that there are no health or safety concerns adopting these rules. And so we would simply ask that you adopt the rules with this would be the permanent rulemaking. The emergency rules end on 11/16 or November 16th. We would ask that you adopt the permanent rulemaking effective November 17th, and I'm happy to answer any questions.
Any questions for Mr. Jennings? All right, I'll take a motion. Accept.
So move, Commissioner Callis.
Second. Second. All those in favor say aye.
Aye.
Mr. Butler?
Aye.
You good?
Yes, sir. I'm good. Thank you.
Okay. All opposed? All right, motion carries. Thank you. Thank you, guys. Thank you to your staff, Mr. Jennings. Thank you for what you did. Let us go to item R, appointments. Ms. Winston, is she on?
Yes, sir, she is.
Mary, are you there? Can we
I
see you?
am here. I'm here. Good morning. Good morning.
There you go. There's your beautiful face. All right, Ms.
Thank
Winston.
you. Yes, it took a minute for my computer to say to wake up. But
There you go.
yes, so for item R, we have appointments and we don't have that many, so I won't take up that much time today. If we could get our PowerPoint up, Christine. I saw Tamala get up.
Hey, Mary, this is
Yes.
Brian Francis.
Yes,
Let's forego the PowerPoint and just go right to the meat of it.
let's do it. Okay,
Thank you.
today we have appointments for our Electrical Safety and Licensing Advisory Board. We have two of those today. We have Mr. Mark Matheny of San Antonio, Texas, and we have Mr. Lydell Toy of New Braunfels, Texas. For our Massage Therapy Advisory Board, we have Miss Callie Harris of Houston, Texas. And those are the only appointments that we have today.
Mary, is it Morris? Or how- I got on my
Morris.
sheet. Okay, you said her. Okay. Callie Morris.
Yes.
Okay. Thank you. All right. By the way, thank you. Great job on getting these spots filled. Commissioners, I can't tell you any recommendations for advisory boards. I welcome them. Mary does a great job of researching, making sure the right people are giving us the right information. I'll take a motion to accept.
So moved.
Commissioner Callis, second.
All those in favor say aye.
Aye.
Opposed? All right. Thank you, Mary. Great job.
Thank you so much. We'll notify them immediately. Thanks so much.
Absolutely.
Mr. Chairman, Brian Francis. Commissioners, keep in mind that at your December meeting, you're gonna have a full slate of appointments for the 3 new advisory boards that were created this legislative session. The combination of Barbara Cos group, the Driver Education Safety Group that's been reconstituted, and then the newly created FMQ from a work group now advisory board. So it'll be a lot more involved, and we already have hundreds of applications that the team is working through.
Cannot say that more. That's a great, we want to get the right people there. There are eyes and ears in those industries. Okay.
Mr. Chairman?
Yes,
Brett
sir.
Bowman, I think the only remaining action item would be the minutes, approving the minutes from the August meeting.
We missed the minutes.
Unless
Did I miss it? I thought we did it, but maybe I didn't.
You did the minutes.
You did the minutes.
Yeah, you
Okay.
did the minutes. No worries.
You gonna throw a grenade just to throw a grenade, Mr. Bowman? Just because we need another grenade?
It's a confetti grenade.
I mean, of all people, Mr. Bowman, of all people, I expect that from Mr. Francis. All right, listen, guys, you held in there well. Mr. Butler, I thank you so much. If you need to go, I understand. I hope you get better. I'm praying for healing and for you and your bride. And so if you need to go, you're welcome. Again, thank you for what you've done. I know you got doctor's appointment. So
Yes, sir.
we'll finish out, okay?
Thank you so much. Goodbye. Goodbye, everybody. God bless.
Thank you, Mr. Butler. All right, so I didn't let him prematurely go, did I, Don?
No, you did not.
Okay, we're gonna go to public comment, because I think we have one. Do we have one? Okay. Appreciate your patience on that.
Chairman, we do have a caller on the line also.
Okay, if they can stand by, I'm gonna do one here first, if you don't mind, Mary.
Yes, sir.
I mean, Tamara. Okay, Thelma?
Yes.
Okay, I'm gonna read you some instructions if you don't mind, okay? Thank you again for your patience.
You're welcome.
All right, so let me go through this. We're accepting public comments in writing, either in person or by video conference call for those who submit a request in advance to speak to commission. Commissioners, we received 3 written comments. Is that right, Tamla? Okay, and those have been provided to you through your emails. We'll bring the first commentary in the meeting. That person will have 3 minutes. You'll have 3 minutes to speak. There'll be a brief pause, and we'll get to the next one, commentary, and that person will have 3 minutes. So, I want you to thank you for being here. Again, appreciate your time. Please say your name and who you represent. You have 3 minutes. Please understand the commissioner is not allowed to ask you any questions or engage in discussions with you about anything that's not specifically on our agenda. Please also understand the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be the decision maker in that case. So do you understand what I just told you?
Yes.
Perfect. All right. You have 3 minutes. Go ahead now.
Okay. I've been doing hair for 35 years. I've owned Hair Tech for 5 years. I'm having a problem with students once they come out of school and they want to go to work. They're not prepared. The hours that they've cut back on them from 1,500 to 1,000 has made them inadequate, especially with COVID. Now, a lot of the students that are coming out of school, their teachers, one of my stylists that I'm having to work with was without a teacher for 4 months, and she still graduated. She was told to look in her, read her book. And then other students come out, they're not prepared to work. And then the other thing was there were some ladies and a gentleman politicking the other day at my house, and they were saying about how now anybody can teach. You don't have to have the 750 hours to teach. Although I have 35 years in the industry, I would never know how to not plan a class, prepare a lesson. I would not know how to conduct a class or to maintain control. I would not know how to speak to someone on the clinic floor as they were trying to correct a student I would take my years of knowledge, but that doesn't mean I know how to represent the company that I worked for are the way to expect a student to have respect for me, because I would then let them know I have the knowledge. So not having the teacher with the 750 hours, I think, is an adequate thing. One of the ladies who was top politicking the other day against it, I live in Houston, so this was for Cy-Fair School District, and I did go to the meeting, the last meeting they had to sue Cy-Fair School District. They were really caught up in the whole thing of the TRC right now, and I really wanted to know more about the regulations for the 1,500 hours in school. So that was why I went, but there wasn't much of that. But one of the ladies said that one of the ladies who came in who's a teacher now, who doesn't have to have any hours, said, well, we could just use the nail glue on the eyelash glue because we didn't have any. And there's gonna be mistakes made like that. If people aren't prepared and they don't have the knowledge, there could be some dangerous things that can happen. Anytime you mix the public with chemicals, you can have problems. And I understand now that it's legal to work from your house if you have a separate entrance. And that became a real popular thing to do, which is causing problems for me. I have an 8-chair salon, and in 5 years, I've only been able to hire 4 people. They'll come, they'll stay for about a year, maybe a year and a half, they'll build a clientele, and then they'll go out on their own and they're going back to their house. And so they use me as a springboard. Well, that hurts my business. And so I'm trying to find ways to now deal with all of the deregulations, because I feel like it's hampered people who own businesses, hampered people who have schools. It's hampered, more importantly, the students who are coming out, because they're not prepared. They don't have the knowledge. They think that they're gonna make this grandiose money all of a sudden, and it doesn't happen that way. When we were in school, we were held our feet to the fire. There were things that we had to know. You were never to do kitchen work. Well, now it's legal, and they can do it with all the social media that they have that we didn't have back in the day. So that there's outlets that they get it, but is it being conducted properly? And I've had one person come to my salon in 5 years to examine my salon. One person. I really wonder how many people are getting to these people's homes that have their chemicals brought to their house through the internet. They can have everything brought to their house.
You got about 15 seconds.
Okay, and the rest I want to say is, please, the new people who are becoming hairdressers need to have the realization that they are still going to have to conduct appropriately. I hear a lot of times how there's about the nudity and that sort of thing. That's not a care of mine, and I'm sure it's a care of yours. People have to conduct themselves appropriately. I care more about the damage that can happen to people's hair and the loss of vision, or somebody having an allergic reaction and maybe have a heart attack. I have an information sheet that you have to fill out, and people sometimes are reluctant to give me the emergency information, which is the person's name and a phone number. Today with COVID, I need that information. Today with anything. But I have $1 million umbrella of insurance. Somebody walks through my door.
Let me go ahead and catch you.
Okay.
I give you extra.
Yes.
It means the world to me.
Yes.
And I know every commissioner here, you come and talk to us.
Yes.
We love that.
Yes.
So we need to hear from you.
Yes.
And so thank you for your time.
Yes.
We can't address, but staff will follow up with you.
Yes.
I promise you that.
I
And
appreciate
so
it.
Being here present will make it
Yes.
first fam. So I'll make sure that happens, Mr. Francis.
Yes, sir.
Okay.
David will be
And
on.
so we'll get that done, but thank you. As commissioners, we need to hear you. So thank you.
I
for your time.
appreciate it.
Ms. Scruggs, right?
Yes.
Okay, thank you. Thank you
Yes.
so much. Tamala, do we have, who's the next? I don't have a sheet for the person online.
Yes, sir.
So
It's
I don't know.
Elton. Mr. Elton is in the meeting.
Oh, does he have a sheet? Do we have a sheet on him?
Right there, Mr. Chairman, on the screen.
Hello.
Okay. All right, Mr. Elton, can you hear me?
Yeah, I can hear you very well.
Okay, let me read this instruction to you. I want to make sure you understand the instructions, and you're gonna have 3 minutes, okay, Mr. Elton?
All right.
Okay. Thank you for being here. Please say your name and who you represent. You'll have 3 minutes. Please understand the commissioners are not allowed to ask questions or engage in discussion with you about anything that's not specifically on our agenda. Please also understand that the commission cannot hear any information about a pending complaint or an enforcement case because we may ultimately be the decision maker in that case. Do you understand, Mr. Elton?
I understand.
Okay, Tamla's gonna keep time. You have 3 minutes, sir. Go ahead.
All right, so my name is Elton Casey and I represent myself. I wanted to thank you all for giving me the opportunity to raise my concerns here today, and I appreciate all of your time. I started working as an electrician in 1997, and that was after finishing a 4-year full-time program in the technology school with a degree in electrical service, electrical field. I moved to USA in 2004 and started to learn the NEC, the National Electrical Code here, the rules and regulations that apply in National Electrical Code, which are a little bit different from the European rules. I became a master electrician in 2012 in the city of Chicago. After fulfilling the eligibility requirements needed to take the test and then taking a written examination test on the National Electrical Code, which is the same book that the Texas electrician take also the examination test. For family reasons and not in any way political or otherwise, I had to move to Texas and wanted to apply to get the master's electrician Texas here as well. But we hit a snag. On the TDLR website, it states that an individual must hold a German electrician license for 2 years before they can apply for the master's. So even though I've been working as an electrician for over 24 years and have held a master electrician license for about 10 years, I cannot sit for an examination, for a test, to get a master electrician license here in the state of Texas. So I had a call with the TDLR last week with some very good gentlemen that represented TDLR and the electrical license department. And they advised me that I have to get a German electrician license test, even though Mr. Daniel agreed that I am overqualified for the master electrician test, but because of this rule, I cannot be actually sitting to apply for a master's electrician test. So I'm not against these rules, and these rules are there to make sure that an applicant is qualified for what is he applying to be. But I think that there should be another way to go about this for people that have spent their life and invested on their life on the trade that they live, and for over 24 years on this. And I wanted to see if there's anything we can do about it.
Michelle, thank you so much for your time. What we're gonna do is I'm gonna have one of our staff follow up with you, make sure that all your options you're aware of, and so we'll follow up with you on that. But thank you for your time and thank you for being part of this. Okay.
Thank you for hearing me.
Okay. All right. Mr. Francis, we can make sure somebody follows up. Michelle, that'd be great.
Mr. Chairman, I've had David Gonzalez assign that, and he's going to continue to work on that.
Perfect. Thank
Mr.
you.
Chairman, I have a question. Since I couldn't ask him, can I ask you a question just for me to understand this? Like, for example, if I'm a physician coming from, say, Louisiana, all I have to do is send my credentials as a physician and I can get licensed emergently in the state of Texas. My question is, and I'd like Brian or Brad to answer this. What was the reasoning behind 2 years? If these people that are master electricians, what is the reason behind making them wait 2 years? I'm just trying to understand it as a commissioner.
All right, stand by before we get into this. I want to make sure that we don't violate anything. So, Brad, are we okay with this or not?
So this is Brad Bowman. The Open Meetings Act does allow if there's a question and we can answer the question with existing law or policy. So we could give kind of a general answer without getting deep into the specifics of this gentleman's particular case.
All right, Dr. Callis, so we're going to answer the question. And so, Mr. Francis?
Brian Francis, Executive Director with TDLR. Dr. Callis, in a nutshell, it's a requirement that was placed in the law maybe about 4 years ago, if not 6 years ago, to ensure that the individuals weren't just academically competent to do the electrical work, but they actually had the hands-on experience. And that could be debated whether or not that's appropriate, but that's my understanding of why that requirement was put in there. Also, yes, I'll leave it at that. That's my general answer.
Good.
Thank you. I was just asking. I'm not trying to get into specifics. I'm just trying to educate myself because I would. I mean, Thank you very much.
Dr. Callis, you can ask me a question anytime, sir. We have that kind of relationship. All
Thanks,
right?
sir. I appreciate it.
All right. Thank you again. All right, I'm going to go to item S, which is sunset implementation, and we're going to throw it to Brad or Mr. Brad? It says Brad.
Christina Kaiser is on the line.
Ms. Kaiser? Christina, where are you?
Good
There you
morning,
go. Good morning, Christina. It's good to see you.
and you as well, sir.
Thank you so much. Your item, sunset implementation, your items S, please.
Hi, good morning, Mr. Chairman and Commissioners. I'm Christina Kaiser. I'm one of the Deputy Executive Directors here at TDLR. As you know, my area of responsibility is regulatory services. I have also had the pleasure for the last year of sort of overseeing the agency's work on implementation of the Sunset Commission recommendations, as well as more recently the sunset bill that was passed by the legislature, House Bill 1560. So about a year ago, when the Sunset Commission, actually more than a year ago now, when the Sunset Commission first published its staff report about TDLR, we got to work on some of the recommendations that we felt we were able to implement at that time, and we didn't really need to wait for a sunset bill to pass. One of those things that we got to work on right away was a training manual for the commission, and you've always had a training manual, but we expected, and it did happen, that the sunset bill added some more specifics regarding what needs to be contained in your training, and it also added a requirement that there be a manual that you receive once a year and sign off on once a year. I want to commend Della and Brad and Wendy and Tamala for all their work on this, and I'm sure I'm leaving out some other people. I would like to yield the floor to Brad or Della, whoever is prepared to tell you a little bit more about the training manual and what you should expect going forward.
Thanks, Christina. This is Brad Bowman. I'll just chime in a little bit here. Derek Burkhalter is one other person I'd like to mention, helped develop some of the rulemaking training. So as Christina said, we already had a training program for commissioners, but because of the changes in the sunset bill, we had to kind of beef that up and add a couple of elements. And so there are, for current commissioners, and that's the training manual that we will use for new commissioners that are onboarding. For current commissioners, there are two requirements that we need to make you aware of, and that we'll be working with you on in the coming weeks to get you up to speed on. One is that current commissioners have to be trained on those additional items that were added to the training manual. And so that has to be done by December 1st. So over the next month or so, Tamala has put together some dates, possible dates for the commissioners, and for about an hour and a half time frame that we can get with you to go over those additional items and kind of walk you through the training manual and sort of what's all there from a very broad overview perspective. And then there's an acknowledgement that each commissioner has to sign annually that you reviewed the training manual. So we'll be getting with you. We'll be putting the training manual out there in your portal for your review very shortly. And then we'll be getting with you to do that follow-up training and make sure we meet that December 1st deadline. And if those dates that you're seeing don't work, we can work with you on other times to make sure that we get that covered. And that's all I have, unless there are any questions.
Commissioners, any questions? All right, Christina, thank you. Della, I just saw you. Thank you. Thank you, Brad, for what you do. We're gonna go to item T, staff reports. Mr. Francis.
Mr. Chairman, first of all, thank you and the commissioners for your attention today. I know it was kind of rocky, but y'all made it happen. You made it work, and thanks to my staff too. It's smooth. I love it. I love it. I also want to extend a welcome to our guest. We have a former chairman, Frank Denton, here in the audience. It's great to see you, Chairman Denton. Great to see you. We're just gonna touch on a few things and hit on them pretty quickly, Mr. Chairman. I'd like for, and I know that the conversations about COVID can be daunting and it's dominating our conversations. I want to just be very brief. You had asked our staff to give you some information specifically about COVID and our staff. So we'll address that, and then we're going to move away from COVID. Then we'll have Mike touch briefly on the Hub Mentor Protege program, just highlighting that. David Gonzalez will touch on state employee charitable campaign efforts. Mike will then jump in on the Veterans Commission and Veterans Day activities that are coming up, and then I will touch on the Texas licensing system. And Kaiser, I think you go first, right?
Certainly. Good morning again, Mr. Chairman and Commissioners. Christina Kaiser, Deputy Executive Director. I wanted to draw your attention to some information that's in the Human Resources Staff Report. That is contained on page 120 of 136 in the PDF document if you wanted to look at what I'm talking about. Mr. Chairman, in a recent one of our weekly check-in calls, you expressed some interest in seeing what the numbers look like in terms of the extent to which our staff were impacted by COVID or folks were not able to work because of COVID. And so on the HR staff report, you'll see that in the right-hand column, Sharon has provided you some information about the amount of staff leave under the federal Families First Coronavirus Response Act, or FFCRA for short. We have some information there about the extent to which people used that specialized leave in fiscal year 2020 and fiscal year 2021. It shows the number of employees who took the leave for the various reasons that are allowed under that act, and then the total number of hours of that leave used in each year. In 20, it was 3,706 hours. In 21, it was 4,067 hours. I'm going to leave that for your review, and I am happy to answer any questions, or Brian, if you wanted to move on to your next thought.
Well, so you tell me for the year of 2021, we're at 4,000 hours, and we haven't finished this year yet, basically, year to date, basically, right?
No, that's fiscal year 2021, which is past. Fiscal year
Yeah.
2021 started
Okay,
in September of 2020.
My apologies.
No problem.
Okay, these are fiscal. Okay, I want to make sure it's okay, fiscal year. Okay, all right. Thank you.
Chairman, Commissioner Mike Harris-Menace, Deputy Executive Director. I want to give you a little bit of update right quick on the Hub Adventure Protege program that we currently have. We're waiting on the final numbers to come out that will give us a final total for fiscal year 21. But right now, what we're showing is that we have spent about 34% of items that are allocated or can be allocated to Hub. And the state average, just so you know, is about 8.34. We'll run about 34%. We did do 10 events in fiscal year 21 that were Hub related. So we attended either in person or online. Most of them were online. And also we added one more mentor protege to our portfolio. So now we have 2 mentor protege programs that we're currently addressing and using right now. So that's kind of a wrap up on the Hub and mentor protege.
Good job. And make sure you get those Hub numbers to Commissioner Collier.
We will.
Okay, because I know this is something she's passionate about.
Right. Yeah, I stay in regular contact with her and give her that information.
She'll stay in regular contact with you.
Yeah.
I know that. All right, what else we got? Brian?
SCCC,
Oh.
David Gonzalez, Deputy Executive Director of Licensing Services, Chairman Figueroa, Commission members. We've kicked off our state employee charitable campaign. It is a focused effort that all state agencies participate in so that we can raise money for all the charities that are available to us to contribute to. Brian takes great pride in this. We actually reached 92% participation rate, which is a really big deal. It's not so much how much we gave. We actually have given more amounts in the past, but the fact that we had 92% participate last time, we're hoping to reset goal or even exceed it this year. There are events planned throughout the month by our team. These are all volunteers from our staff that are doing extra work to make sure that we've got focused efforts, whether it's Balloon Appreciation Day, where we recognize our peers and purchase balloons with money that will be dedicated to the charities of our choice. There can be dedications, talent shows, dedications from silent auctions of monies, again, to those charities. Those monies that are raised during the silent auctions would actually go towards the charities. We even got a spirit stick going where we may actually get our executive director to wear colors not of his choice for his favorite team, perhaps University of Texas, perhaps Texas A&M, depending on who raises the most amount of monies, to get him to wear different kind of colors. But it's all in the name of charities. We even, for our kickoff, had some of the charities come and do presentations for us to let us know about their charities and the things that they achieve. So we're really excited about that, and hopefully it's going to be a success as you. In fact, I know it's going to be a success as it was last year.
Did you throw my wrench in there?
Oh, yeah, it's in there.
If you want to make mention,
I want to make sure.
I know you offered something for our silent auction, perhaps staying at the main house at Figueroa.
I have cooking duty. Francis has janitorial services. We'll be fully staffed. Don't you worry. Whoever wins that, make sure we fully staffed.
Appreciate that generous offer.
And we'll make sure he wears the appropriate colors during janitorial services.
Oh.
All right, what else we got?
Chairman, I'm gonna take up the Veterans Committee meetings and Veterans Day. I would make mention that on September the 8th, we held a Support Our Veterans event online that was primarily focused towards our employees, but we also did include the Article 8 agencies to participate. We managed to get a lot of information, a lot of participation from various other organizations, outside organizations, from the Texas Veterans Commission, Samaritan's House. So there's a lot of individuals that were speaking on various topics relating to veterans, suicide prevention, families that have to go through also with this with their veterans. This came out of a concern that one of our directors had over an employee that was dealing with the withdrawal out of Afghanistan that was taking place towards the end of August, when the decision was made to withdraw out of there. The employee that we had had served a couple of tours in Afghanistan and was dealing with that whole thing. And it just so happened that particular weekend that I was notified by our director, I noticed a story that was being put out there about veterans that were dealing with the withdrawal. So that kind of became a paramount push for us. Our executive director said we need to do something right away. So within about a week, we organized the event. There's a lot of people I need to thank. They know who they are, so I won't go through all that. But I did want to mention that we had a great event to support our veterans here at TLR and also other Article 8 agencies. We hope to be able to continue that on in maybe some other form of fashion. Still doing that. I would also let you know that we're currently preparing for Veterans Day. Our chairman videoed a message yesterday for veterans, so we hope to be able to release that fairly soon, or actually release it on Veterans Day. I do want to talk about a big event that we were at on August 13th. The Texas Workforce Commission held an event where they were recognizing organizations, businesses, other organizations that are part of the We Hire Vets program. TDLR received an award. At that time, we had about 12.5% employment of veterans within our agency, which was one of the highest that they have. There's other private industries that run about 20%, but Chairman Demerson, Aaron Demerson, who is with the Texas Workforce Commission, stated this was the first time that he remembers providing this trophy or this award to a state agency. So we're fortunate to be able to receive that. We are currently running about 12% veterans employment rate here at TDLR. So we're pretty proud of that, and we'll showcase that as much as we possibly can also. So that's all I've got on the veterans. Thank you.
Great job on the veterans and great insight. I'm very proud of our commission to be able to recognize needs, respond quickly. So congratulations.
Mr. Chairman, the last thing before we go on, I do want to commend Mike. I remember early on when we were trying to figure out what interests do the deputy executive directors have. You know, what do they want to take up? Christina took up Sunset. David's taken up the licensing system. Mike ran to the veterans. That's something that he was passionate about. And I see it in his responsiveness and the connections he's building there. So I'm very grateful to everything he's done and his leadership in that particular area. So commissioners, I'm typically coming to you with slam dunks and a lot of success. I'm gonna share briefly with you an area where I've failed and have not lived up to my expectations. On the Texas licensing system, we did not renew the contract with the vendor we were working with. It was not on path for us to be successful. We pulled the plug on that. It was a very tough decision, but it was the right decision. I've been meeting with my team regularly every week since we made that call, and the path that we were outlining, we'll share with you as we go forward, but that path is aggressive, but it is built and it weaves in the mistakes and the errors that we make going forward. It is one that's going to get us where we need to be. I will continue to keep you apprised of it. I'm going to ask the chairman to identify 2 other commissioners, including himself, that we will report to quarterly so that we will be accountable in getting this done and getting it done well. I will tell you that the approach that we're going to take is going to be one where we will know that the vendor can be successful before we engage them in a long-term effort. That is one of the biggest changes that we're going to make, but also building in the accountability at the commission level. So you'll be receiving periodic video messages from me, bringing up to speed on where we were, the results of our after action review, and how we're going to get there and be successful.
Wonderful. Any questions for Mr. Francis? Okay. Yeah, promotional for personnel changes, anything like that?
Yes,
We have one.
Chairman Mike Harris-Bennett, Deputy Executive Director. I'm pleased to announce that we, of course, as you know and aware, Jody Ashlock had left the agency back in about March. I've been kind of running as interim IT director, CIO. It didn't take me long to figure out that I needed somebody else to run that. So
Couple of minutes.
I'm pleased to announce that we hired John Fowler, who is currently working over the Texas Workforce Commission, to be our new CIO. He will begin next Friday, October 15th, and start as our new CIO for the agency. John has a deep history over at the Texas Workforce Commission. He's been there over 20 years. He has solely been responsible for all the unemployment insurance claims that have been going out during the COVID period. I had coffee with him yesterday, and he said that when he left, they had just surpassed 56 billion. And so he was the one that was responsible for ensuring that all those were going out from the employment claim. So he comes with a rich history. I tell you that when I checked references, he had nothing but glowing references from everybody that I talked to. I mean, I tried to go in and find some dirt on him, and he was pretty clean. Which is great for us. So he'll be at our next meeting. We'll be able to properly introduce him to the commission member. I do want to let you know and welcome John Fowler as our new CIO.
Good job. Good job.
It's great.
Mr. Francis, Mr. Mike's in charge of IT. That's
well, you may have witnessed some of his work yesterday. He was over Facebook and Instagram yesterday, just for one day.
Good job there, Mike.
One day they have in charge of that.
I saw that one file we didn't think, so I just got rid of it.
One button. It's just a button. That's all. Button.
Mr. Chairman, that's all we have on this end.
Okay, so we have plowed through this. Dr. Callis, I can't thank you for hanging in there. Causes hair loss. Stress does. Work on that. Our next meeting is going to be November 16th. Tam, is that correct? We lost Tam somewhere.
No, sir, I'm here. That is correct.
November 16th. Commissioners that are here, and I'm gonna send a note, we're gonna expect everybody to be here. So block that day, seal that day, do what we gotta do to be that day. I wanna make sure and secure that quorum as much as possible. So November 16th, 8 a.m., whatever we gotta do, we're gonna confirm that and get that situated, okay? All right, I'll entertain a motion to adjourn.
So we'll make a motion to adjourn.
All right, adjourn.
Thank you, commissioners. Appreciate you.